Ladies and gentlemen, today what we are facing is clearly a new normal where we have been facing pandemics, lockdowns, and now even cyclones have been gracing Mumbai. But rather than facing on the obstacles and the challenges, my mind is drawn to a very famous quote by Charles Darwin, who is credited with the theory of evolution. And Darwin says that it is not the strongest of species that will survive, nor the most intelligent, but those who are most adaptable to change. Today, we are seeing a world change, and the key to success lies in adaptability. Giving you an example, in 1664, England and London was facing a similar pandemic like which we are facing today. So this was the bubonic plague, and there was widespread death, disease, and destruction. They also were facing a lockdown similar in the nature as we are facing, where businesses, schools, colleges, universities had shut down. And amongst these was Cambridge University, which also shut down, advised its students to go back home and study from home. One student decided to grab this opportunity, and he indulged in deep studies and came out with work which we today know as the laws of motion and the laws of gravitation. This student was none other than Sir Isaac Newton. And Newton, in that sense, personifies the phrase that when life gives you lemons, we make lemonade. Meaning, when confronted with challenges and trouble, we create opportunities out of these challenges. And today, as we see, while we discuss the lockdown and the various challenges that we face, the world and the wheels of the industry are moving forward. The world has become a virtual world. And we have virtual conferences, virtual webinars, virtual education, virtual court hearings, and even virtual marriages, what we heard recently. And in that sense, adaptability and changing to these changing circumstances is a key which we need to understand as we move forward. And even talking of lemons and lemonade in the context of our today's discussion, this pandemic and the lockdown has thrown open a number of challenges to deal with, a number of contractual issues, issues to do with payment of wages, issues to do with payment of rent. All of these issues represent the lemons which has been presented to us. And what opportunities we can make out of these, what learnings we can adapt into the future, what feedback we can take from this episode, govern our future relationships, our future contracts, are the lemonade that we will discuss today in the context of our discussions. So, having said that, let us discuss our first issue of our topic today, which is the challenges faced by contracts in connection or arising out of the pandemic and the lockdown. As we all know, that the lockdown has seriously affected the ability of companies to comply with their contractual obligations. And what was routine and regular at one stage has become something which is profoundly difficult and onerous to perform. So therefore, what happens in such a situation where parties, without any fault of their own, are confronted with a situation where they cannot perform the contract or they cannot perform to the best of their ability as had been initially contemplated under the contract. So, focusing on the discussion, if we can divide our talk on contracts into two aspects. One, the contractual aspect of force majeure, and the purely legal concept of discharge by way of frustration. So, since contracts have become very difficult to perform, obligations are being breached, and therefore recourse can be made to these two principles, and the statutory foundation to this lies in two sections of the Indian Contract Act, namely Section 32, which deals with contingent contracts, where contracts are contingent on happening of a future event. They can only be enforced if that event happens. And more importantly, Section 56, which talks about impossibility of performance. Contracts which are otherwise legal subsequently, because of supervening circumstances, become impossible or impracticable to perform. So this is the statutory or the legal basis which will govern our discussion today as we speak about these two aspects. And taking the contractual aspect first, the concept of force majeure. This is, as they funnily say, that God is everywhere and he even finds himself into our contracts. So this is a clause which is referred to as the act of God clause or the force majeure clause. And the underlying theme of this clause is to protect the contract, to revive the contract, to keep the contract alive. It is virtually like contracts on ventilators, where your obligations get suspended or deferred for a given period of time, and thereafter the contract sees through this situation, this impasse, and then revives again. So the rights and liabilities which are intermittently suspended, they revive again once the force majeure event is abated and is no more existing. So this is also a very interesting concept. When talking to lawyers, when I started my legal profession, I was told by a very eminent senior counsel that there are two kinds of lawyers. One are the preventive lawyers or the transactional lawyers whose duty is to draw up robust agreements that can survive the test of litigation. Or if it does go into litigation, because the clauses are so well drafted, they maximize the chance of your success in litigation. And the other side, the other type of lawyers are the curative lawyers or the dispute resolution or litigation lawyers. When things go bad, you rush to your doctors. So these are your doctors who perform your surgery or they treat an ailment when the illness surfaces itself. So these are the dispute resolution lawyers. So here, talking of force majeure clauses, we are talking at the role of transactional or the preventive lawyers who draw up agreements and put in robust clauses so that a situation, if it arises, it can be enforced effectively. As you know, Supreme Court has recently come out with the rule of business efficacy and economic justice, meaning it will look at interpret contracts a way the businessman or a business person understands. They will step into the shoes of a businessman and give an interpretation which a businessman would normally give to a particular term of the contract. So that is a very welcome development in statutory interpretation, where courts also think from a business perspective, talking about contractual clauses. So talking about a force majeure clause. Now, of course, as we know, in a lockdown situation or any other similar situation, performance become impossible or very, very onerous or difficult. Here, we have a contractual clause that gives you a way out. So this is something very, very significant, even for future drafting when we enter into contracts, draw up contracts, to look at a force majeure clause from this perspective. So if you look at the broad aspects, I can divide it into four essential fundamentals for a force majeure clause. One, you define the force majeure event. Two, you discuss the manner of invocation. Three, and most importantly, you talk about consequences of happening of a force majeure event. And lastly, the duty of every party to try and mitigate whatever loss or damage occurs. So talking about the first aspect, normally you will see force majeure clauses where there are special words such as war, natural calamity, government embargo. So these are specific words, and following them are general words. Such other circumstances beyond the control of the party which affects a contract. So you have a mixture of special words which are specifically contemplated and general words which follow these specific words. Here, the legal principle of interpretation is something what we know as ejusdem generis, meaning the general words following special words will draw color and will be interpreted in the same sense as the special words which preceded. So when you talk about war, natural calamity, and such other circumstance, the term such other circumstance will draw color from war or natural calamity to mean a situation which is akin to impossibility, something which is completely beyond, which is not something which is a routine, regular commercial risk. So you cannot qualify events such as commercial risk, price fluctuation, fluctuation in the price of raw material, and other generally accepted and known business risks with this general clause. It will have to be something akin to impossibility, like war, natural calamity, which is so grave, beyond the control, that a party is impeded from performing. Here, to give you an illustration why, as far as possible, it is better to put in the specific words and contemplate as many as you can, rather than leave it to the rigors of judicial interpretation. And of course, you cannot provide for every possible situation in every possible circumstance, but to the extent possible, you can provide for the same. And to give you an idea of how courts normally would look at this kind of a clause, there was a case which I had done in a securities litigation, which went to SAT and eventually to Supreme Court. Here, it concerned the SEBI takeover regulation. So, as you know, when shares are being acquired of a public listed company beyond a particular threshold, the acquirer has to make an open offer to the general public to purchase a particular quantum of shares from them. The idea is to give them an exit option if they want to exit. So here, there was a provision under the old takeover code which said that an open offer once made can only be withdrawn in case of three situations. One was death of a promoter. Number two, a license is not forthcoming from the government. And number three, such other circumstances which in the opinion of SEBI merit withdrawal. So in our situation, what happened? Our client was a company who was acquiring certain shares, and they acquired the shares of a public listed company. And consequently, they made a public announcement for an open offer from the general public. Thereafter, what they realized is that there was a massive fraud in the company. And therefore, they quickly approached SEBI saying, look, here is a situation where I did not know, there was no way for me to find out that there was a massive fraud. And under this regulation, there is powers vested to SEBI to allow withdrawal because either it's death of a promoter or license not forthcoming or such other circumstance which in the opinion of SEBI merit withdrawal. So this fraud will qualify as such other circumstance, and therefore SEBI should allow withdrawal because it is completely beyond my control. I could never have envisaged that there was such a massive fraud. What happened was SEBI refused, and the matter went to SAT and eventually to Supreme Court, and the final ratio here is that the concept, the exact same principle which we discussed was applied of ejusdem generis, meaning license not coming, have to draw color from these specific words. Meaning, if you want an open offer to be withdrawn, the only reason you can give is something akin to impossibility. So it cannot, even in a situation of fraud, will not be an exemption from an open offer because it is not something which is in that sense rendering impossible a situation for allowing you to make an open offer. They would argue that fraud can be determined through due diligence. You could have done extra due diligence and various other arguments. And therefore, the principle which we are talking about of ejusdem generis was applied. And even in a force majeure situation where you have general terms following specific words, such a tool of interpretation could very well be applied by the courts. Recently, we had the Ministry of Finance and Ministry of Shipping all notifying in context of COVID-19 that COVID-19 would be considered to be a natural calamity within the meaning of force majeure clauses, and the relief should be given. So that is a welcome development. COVID-19 can be treated to be a natural calamity and appropriate remedies can follow. So having said that, this is the first aspect of a force majeure clause which we have discussed, which is about naming the force majeure events to the extent possible rather than leave it open to interpretation. The second aspect is about the time and manner of invocation of a force majeure clause. So normally you will see clauses which say that within 7 days or within 10 days of happening of a force majeure event, you should promptly notify the other party about the event and that you will not be able to perform because of that event. So obviously a lot of emphasis is put on prompt disclosure, which is very, very important. Also material in this circumstance is something which we have seen in long-term contracts, where, for instance, you have to build a road or a project within a given period of time. If time is lost as a result of a force majeure event, where obligations are suspended, you will see there are clauses which say that there will be a corresponding increase in time subsequently at the end of the contract. So suppose in COVID-19 and pandemic and the lockdown, you have lost 3 months to perform. You can provide a clause that there will be a corresponding increase in time of the period lost once situation normalizes. The third aspect dealing with a force majeure situation or a force majeure clause are to provide very clearly of consequences of happening of a force majeure event. So you may provide at the first instance, like in a regular standard clause, that the obligations and liabilities will be suspended. So therefore, a party which is adversely affected will not be required to continue with the very same liabilities in a force majeure situation, and the liabilities initially will be suspended. So that gives a chance for the contract to revive in future. Thereafter, you will also see there are clauses which say that if the force majeure event continues for say 90 days or 120 days, which you can provide, the contract can be terminated and put to an end. So therefore, initially you start off with suspension, eventually you end up with termination. We have seen leave and license agreements, lease agreements, rent agreements, which have clauses which say that if a property is unoccupied for a period of 30 days, 45 days, etc., in such a case, if a licensee is not able to occupy it because of things beyond his control or a government regulation, the license can be terminated. So even in this situation of a rent dispute or a leave and license dispute, you may have clauses which provide for an exemption or provide for termination or provide for suspension of rent. So these are some aspects which need to be borne in mind while you are drafting a force majeure clause. Lastly, you will see many force majeure clauses which specify that it is a duty of the party suffering to try and mitigate the losses and damages. It does not mean that just because you've triggered a force majeure event that you will be absolved of all your obligations. You have to continue to perform to the extent possible. You have to mitigate the loss and damage to the extent possible. So this is also something to be kept in mind. Now, looking at how courts are looking at force majeure clauses in the recent past to deal with COVID-19, the pandemic, and the lockdown, let me give you a very recent example of the judgment passed by the Delhi High Court in the matter of Halliburton versus Vedanta. So before I tell you about the facts of this case, let us understand the law as it stands in connection with enforcement of bank guarantees. So bank guarantees, normally you will see for many contracts, secure performance obligations. So if I have to perform something under a contract, I may give performance bank guarantees as part of the contract. The law governing injunctions or stay on enforcement of bank guarantees is extremely strict, extremely rigid, And it's only in very, very exceptional situations will invocation of a bank guarantee be stayed by a court. So that is a general principle which I wanted to brief and highlight before the group as we talk about the law of invocation of bank guarantees. Now coming to the facts of this case and the force majeure clause, Halliburton had entered into a contract with Vedanta for development of certain oil fields. Now they had given 9 bank guarantees as part of their performance obligation. The contract was going on, and then the lockdown, the pandemic started, the lockdown happened, and Halliburton invoked the force majeure clause, wrote to Vedanta saying that they were not able to perform as a result of the lockdown and the bank guarantee should not be invoked. Since they did not get a favorable reply, they approached the Delhi High Court, and Delhi High Court at the first instance on a prima facie basis looked at the force majeure clause, looked at the agreement between the parties, and looked at the lockdown situation, which was very, very unique and severe, and did grant an ad interim stay, an injunction on the invocation. So a stay was granted initially by the Delhi High Court. This happened in around early April. Thereafter, last week, when the matter came up for detailed consideration and detailed hearing, the court observed that yes, there was a force majeure clause, but in this situation, the default by Halliburton pertained to a period prior to the pandemic and lockdown. So the defaults pertain to the year 2019, and therefore recourse cannot be made to the force majeure clause using COVID-19 as an excuse to do away with performance. And having said that, the injunction which was granted earlier was vacated. So here again, this gives us some insight as to how courts are looking at situations emanating from the current lockdown situation, dealing with COVID-19. In a situation on a case-by-case basis, relief would be given. Force majeure clauses, if applicable to the facts and circumstances of a case, would be applied. However, at the same time, COVID-19 and lockdown will not be allowed to be used as an excuse to really renege from obligations which have fructified prior to the lockdown and the pandemic. So that is also some interesting jurisprudence which one can look into and read up whenever possible. And it's a developing jurisprudence. We have seen courts deal with so many cases day to day by way of virtual hearing, which can really be something to be looked at to see how courts are looking at these situations and what kind of orders they have been passing, looking at a balanced approach, trying to come out with a working arrangement so that interests of all parties are balanced. So this deals with the first aspect of force majeure,